Good morning, ladies and gentlemen. Our first case for argument this morning is Krasno against Mnookin. Mr. Berry.
May it please the court. Good morning. My name is Christopher Berry on behalf of the plaintiff and appellant Madeline Krasno, and we come before the court asking to review and reverse the grant of summary judgments for the university against Ms. Krasno's First Amendment claims. The university created its official social media pages in order to communicate with the public about the university. Yet when one of its alumni did just that, criticizing the university for its animal testing program, the university responded by tracking her off-site private activity and censoring her topical commentary by manually hiding comments, temporarily restricting her accounts, and employing a keyword filter intended to automatically remove all comments by anyone mentioning words like animal testing or torture. These actions are unconstitutional viewpoint discrimination, and the university justifies...
Well, that's true only if this is subject to the usual rules about public forums. So I think that's where we need to go. And I have a very simple question, which is, why is this outpost of university thought any different from the alumni magazine?
Well, Your Honor, the social media page from the university, the purpose of it is precisely a place where the university can communicate with the public and where the public can communicate
That's why
with
I
the
asked,
university.
why is this any different from the alumni magazine? That's the function of the alumni magazine. I just got the alumni magazine from one of my colleges. It had 8 pages of letters to the editor. They had obviously been picked by the editor. They didn't claim to publish everything. So the question I'm asking is, why is this way of communicating with the public on, say, a Facebook site any different from the alumni magazine, which sometimes publishes letters to the editor but turns down some?
Your Honor, it's because, as the Garnier Court recognized last year, the Ninth Circuit decision, that there is unlimited space and time that these social media platforms offer. So unlike a traditional publication or even a city council meeting, a park, where a lot of these public forum analyses are directed towards, when we're online and on social media pages, including the comment threads at issue in this case, there is unlimited space and time, and the usual concerns...
It doesn't answer my question. It's a statement of fact. It's, of course, false. Nothing is unlimited, right? There may be more space. Nothing is infinite, except maybe the universe. But it doesn't answer the legal question why there is a difference. Your answer to my first question obviously agrees that the university, as the publisher of the alumni magazine, can choose what's in it, right? And could have, and for all I know does have, a no Krasno policy for letters to its alumni magazine. I can't see why, as a legal matter, this is different. That's my problem.
An important distinction to make here is between the posts and the comment thread beneath the post. So on each page, the university...
You're just telling me something about facts. I'm asking about law.
Well, the law recognizes the distinction between government speech, where the state itself is making the speech, which would be the posts...
No, not where the state is making the speech. That's why I asked about letters to the editor. The letters to the editor of the alumni magazine are the speech of the letter writers. But the university, as publisher, as editor, chooses what will be there. And here we have this website where the university, as publisher or editor, claims a right to choose what will be there. That's why I'm asking a legal question about why there would be any constitutional difference between the two.
Okay. And again, Your Honor, I think that goes back to the point where, as in the alum magazine, there is limited space, and in order to have any letters to
Why is that a constitutional question?
the constitutional, the reason that that's constitutionally relevant.
Let me put it this way. If you ask whether a public park is a public forum, the answer is yes, although there's limited space, right? You can't have an infinite number of people saying an infinite number of things at the same time. But it's a public forum, notwithstanding the fact that there is limited space and time. You don't want to say that about the alumni magazine, right? Okay, I see we're not getting very far on this question. You mentioned the Ninth Circuit's opinion in O'Connor-Ratcliffe, or Garnier. I'm puzzled that you have not noticed, the adversary appears not to have noticed, that the Supreme Court has granted certiorari in that case. What are we to make of that fact?
Well, Your Honor, even setting aside the presidential value of the Ninth Circuit analysis, the Ninth Circuit analysis in that case is
I'm not
informative.
asking about the Ninth Circuit analysis. I'm asking about what we are to make of the fact that the Supreme Court has granted certiorari.
I think that's immaterial because this case, putting aside even that analysis entirely, the record here shows, in fact, that there is, that the purpose of the social media pages is to allow and foster expressive activity. There's nothing in the record at all that there is any sort of practical or material limitation.
What does that have to do with my question? The significance of the grant of certiorari, or the significance of the fact that the Sixth Circuit expressly disagreed with the Ninth Circuit, and the Supreme Court granted certiorari in that case too, or the fact that the Supreme Court has asked for the Solicitor General's views in the net choice cases, in which I think a grant is likely next week. Right? We've got a field where the Supreme Court is active, and I'm trying to figure out what our role is as an inferior court, given the fact that this is on the Supreme Court's docket. That's the burden of my question. What should we do?
Certainly, it indicates that the Supreme Court is interested in this, that this is an issue of public importance given the increasing role and the nature of social media comments, social media pages, and interaction.
Do you think we should wait until the Supreme Court rules before we delve into your case?
Your Honor, that's a prudential question, and I'm not clear exactly what the Supreme Court has granted writ on, what question in particular it's asked there. I know in the
I'm
the
just shocked that you're relying on a Ninth Circuit case and you haven't even noticed a grant of certiorari. I mean, why haven't you read the petition? Why haven't you read the briefs? It's very easy to know what the Supreme Court is considering.
Regardless, go ahead, Your Honor.
All right. If we were to agree with you that the social media sites are non-public forums, what would this mean? In other words, is it your position that there could be no regulation at all? Or what regulation of content do you think would be permissible?
Well, Your Honor, in analyzing this as a designated forum, the university in this case, in a case, or the government generally, does have the ability to impose restrictions and limits on a forum that it creates, and that could include an off-topic limitation. However, it would have to be properly implemented according to the First Amendment case law, which means that that there needs to be actually be a policy or a regulation, which doesn't exist here. The university doesn't actually prohibit off-topic comments through its social media statement. It only says that moderators may remove them if they're off-topic. So you need more than the undeveloped policy that the university is here, and it needs to be implemented in a way that's non-discriminatory. And
But
Does
what,
the u-
what do you think the university would have to do or say on its social media sites to limit comments enough to make them qualify as non-public forums?
Your Honor, the university would need to essentially provide reasonably clear and definite notice about what its restrictions are, and to consistently apply those in an even-handed way. None of those factors are present here, but for example, if a policy said that all comments must be on topic, and then to be clear about what that means, is it on topic with regards to the purpose of the page, which, as the record shows in this case, is about the university generally, or is it with regards to being on topic for the post? And how is that determined?
How far would you take that? Many legislatures will receive comments from the public, and many legislative hearings do, right? They're designed for the public to talk to the legislature. And yet, anything that's off topic will be ruled out of order. Does the President of the Senate need to publish a set of regulations before ruling out of order any comment that doesn't appear germane?
Certainly this can be and should be limited within reason. In this case, the university's policy is unreasonably unclear. And
The President of the Senate doesn't have any public policy, any at all. The Senate follows Robert's Rules of Order, which says that non-germane comments may be excluded. Period. That's all it says. Is that constitutionally deficient in your view?
that may not be, well, is that constitutional? I'm not familiar with the Robert's Rules or how they're implemented.
I just told you what they say.
It's
Non-germane comments may be excluded. Period. That's it.
An important part of the inquiry also is the way that it's enforced, and there's no even-handed or just
So
enforcement
do
here.
you think somebody who wanted to say something in a Senate committee but was prevented on grounds of germaneness could file a lawsuit to ask the federal judiciary to tell the Senate what comments it had to listen to?
Your Honor, again, it goes back to a fact and circumstance dependent inquiry.
I've told you what the rule is. Non-germane comments may be excluded. Nothing else. You were making the argument that there has to be something like a code of federal regulations, detailed definitions, rules of procedure, and so on. That's not how legislative bodies that receive public comments work. I'm asking whether, in your view, that's all unconstitutional.
Well, Your Honor, I think this ties back actually to the point about the alum magazine, which is you can't publish every letter to the editor, and you can't let every person perhaps at a Senate committee meeting or a city council meeting give comments about anything they want to, because there are time and space limitations that would in fact be very disruptive. That the government's limitation of that so that other people can speak, and that so people don't have to be at a city council meeting for 48 hours before it adjourns is a very reasonable limitation. That's simply not present in the online context, and I think that is an extremely important factor that demands a different outcome in this case than in the hypotheticals that are being
Has the
presented.
Supreme Court ever said anything like that?
Well, what the Supreme Court has said is that we
Has
need
the
to look
Supreme
to
Court ever said anything like that?
we need to look at the nature
No,
of the
the
forum.
answer is yes or no, and then you can tell me if it has, where it has, and if it hasn't, you can explain the significance. But I wish you'd address my question.
I don't know offhand that the Supreme Court has addressed that in these exact situations, but we do have a guiding
Or
principle.
any situation
Any situation.
at all. Has the Supreme Court ever said that as a constitutional matter, what determines the constitutionality of exclusion is whether something is unlimited? Has it ever said that?
Not in those words, but what the Supreme
Or in
Court
any
has told us.
similar words?
What the Supreme Court has told us is that we must consider the nature of the form, whether it's compatible with the type of activity here, and that
So
goes.
if we agree with that, with your definition, that the First Amendment can be restricted based on the forum, looking at the case in front of us, if we were to proceed before the Supreme Court rules in the Ninth Circuit case or the Sixth Circuit case, is your contention that the comment section, the interactive comment section, is a designated public forum?
Yes, Your Honor, and
Can you tell me why?
it's a designated public forum because, well, there are two factors we need to consider. First, whether it's compatible with expressive activity. Both Facebook and Instagram say the purpose is for expression. The district court found that was easily met, and in fact, looking to the purpose of the university and having these pages, it is to foster communication between the public and the university. And additionally, look to the purpose and the practice, and the purpose and the practice, the policy and the practice of the university in attempting to limit the social media forum is inadequate because the restrictions are undeveloped. The social media statement simply says moderators may remove comments that are off topic. It doesn't explain how that's
So the
determined.
argument that I'm hearing this morning is that because the University of Wisconsin-Madison has not defined the parameters of how people can interact or use the interactive comment section, that qualifies it as a designated public forum and not a non-public forum?
Your Honor, that is a part of the inquiry, or that is certainly a part of the analysis. It also doesn't, the policy or the statement from the university says nothing about using keyword filters, and I think that this gets to an elephant in the room, both with regards to this questioning and the district court analysis, which is the viewpoint discrimination. The way that this has been implemented is uneven-handed, and...
I'm sorry, counsel. Judge Rovner was commenting.
Excuse me. Yes, Your Honor.
Suppose the university used the keyword filter, but the commenter would get an automatic notice about her comment that it had been hidden and a message about how to appeal. Okay? Would that change your analysis of, the constitutionality of the keyword filter?
No, Your Honor, for two reasons, and that's because both the RAV case and the Lamb's Chapel case from the Supreme Court require a finding of viewpoint discrimination here. In the RAV analysis, Justice Scalia wrote a quote that I think is extremely relevant here, which is that the state may not license one side of a debate to fight freestyle while requiring the other to follow the marquee of Queensberry rules. And what I mean by that is that these keyword filters target, and the university has admitted, the record shows that this is intended to target anti-animal speech. And so or anti-animal testing speech, anyone commenting about animal testing, to have their comment be automatically removed based on some prior determination that the comment must be off topic is simply improper. And as an example of that,
So is it the contention that the keyword filters is on its face viewpoint discrimination,
Yes, Your
regardless
Honor.
of the forum?
yes, particularly the way that it's used here. For example, in a comment where the university says science is awesome, and then talks about a cool science image contest, my client responded saying your science involves research on non-consenting animals, and then had to spell out animal testing, A space, N space, L space, M space, A space,
So she
and
gets
so
around the
forth.
filter.
Because
You
she
only
was
got
aware of
30
the
seconds.
filter. Had she not done that and that comment had been automatically removed, the university's post about science, of which she was criticizing the university for its science, would have been automatically removed, whereas anyone saying science at any cost is great, or touting the maybe the results of some research that the university had done that relied on animal testing, that relied on cruel animal testing, would not have been removed. And that sort of categorical exclusion of viewpoints is exactly the situation in Lamb's Chapel, where essentially a categorical limitation on a type of speech, in this case animal testing speech, would be automatically restricted regardless of whether it was responsive to a permissive topic or not. And so what the university has done is had sliced off, excuse me, Your Honor.
I think the error in your argument is starting with Lamb's Chapel and not Cornelius, and clearly defining the forum and the forum's intent, and dealing with the social media statement, when it was put in place, what guidelines or restrictions were put in place for how the comment interactive section of the social media pages were to be utilized, because that's the launch point for the court being able to assess whether or not this was viewpoint neutral or not, and was this content neutral. If we don't start there, we can't answer the other questions.
We did start our analysis with viewpoint discrimination, and that's because viewpoint discrimination is unconstitutional regardless of the forum. And
But it goes right back to Judge Easterbrook's statement: can you yell out in the middle of a Senate hearing, irrespective of the topic that's being dealt with on the floor?
No, and that again is because of time and space restrictions. I would note, for example,
All right.
I think a good analogy.
Then I'd like you to come back to the alumni magazine,
Correct.
because the University of Wisconsin publishes its alumni magazine on the web. So is it your position that in the web version of the alumni magazine, every letter to the editor must be published, unedited?
Well, because it is a traditional curated publication, that creates additional restraints. I would proffer
There's
to the
no
court.
space restriction in the internet version. The University of Wisconsin will not run out of electrons.
It would require additional time in order to curate that, and the government has been under no
Your position
obligation.
was that it could not be curated. Whatever was submitted has to be published.
Well, in fact, if there were a comment thread, if there were comments allowed in response to that, my answer would be yes.
I'm not asking about comments yet. I'm just asking about letters to the editor. There's an online version. The number of electrons in the universe is very large. Must the University of Wisconsin publish in the online version of its alumni magazine every letter submitted unedited?
No, because that is government speech. Whereas in the comment threads, this is an area where people can talk
don't understand
independently.
the difference. The letters to the editor are not government speech, but the government is the editor.
It requires a placement. A letter to the editor, for example, requires somebody to place that. Someone at the university to proactively
Cut and paste.
And that's not present here. And what I would suggest to the court as an analogy is that, unlike shouting something or ranting about an off-topic thing at a Senate committee meeting, that a comment that someone posts independently on their own, that's their own speech in a comment thread underneath the university's post, is no different than the scales of justice that I have on my tie clip right here, which is that you may notice it and ask me questions about it, or you may think about it, or your eyes might just go right over it the way someone can scroll past a comment in the social media comment thread. That the amount of disruption caused by even an off-topic comment, which we certainly dispute whether it's
I think we have
off.
your position, counsel. Judge Rovner, any further questions?
No, thank you very much.
Okay. Thank you, Mr. Berry.
Thank you very much.
Mr. Kilpatrick. And I would like you to begin with roughly where I began with Mr. Berry, which is, what should we do given the fact that the Supreme Court has granted review in two similar cases and may very well next week grant review in two more?
Yes, Your Honor. In the Garnier case, I believe that the question presented is whether school board officials engage in state action by blocking members of the public, and that, I believe, is a different legal issue than is here. Here, the university did not argue that the means of moderating by the defendants was not state action. I do understand, though, that in Garnier, the Ninth Circuit Court of Appeals determined that
No,
media...
we're not interested in what the Ninth Circuit said, nor in what the Sixth Circuit said in the case that conflicts with it. I'm trying to figure out what we should do in our role as an inferior court, given the grant of certiorari, given the grants of certiorari.
Your Honor, given that I believe that the issues are different, state action is not present here, I believe the court can continue.
Have you read the briefs?
No, Your Honor, I have not.
What the parties are arguing about is about the significance of the fact that some public official who's participating on a website like Facebook is not doing anything different from what any member of the public can do on his or her own Facebook site. Right? Facebook makes certain tools available. The parties argue that Facebook is itself private territory. And they say when a public official uses the same tools that a private person uses, there's no extra constitutional overlay. Now, the technical legal question may be different, but those are important arguments in a case like this. So how should we respond?
Then the university would not be opposed to this court waiting and taking its time to make its decision on whether to affirm here, which we ask, until after the decision of the Supreme Court takes place. But again, Your Honor, it's our position that this court can and should affirm the decision of the district court.
Before the Supreme Court rules?
No, if the court chooses to wait, then the court, the university is not opposed for the court to wait.
Mr. Kilpatrick,
Yes.
what is the current state of the filters? Do they contain the same set of words as they did during the relevant times of the alleged injury?
No, Your Honor. Obviously, this is not in the evidentiary record, but I did check with my client, and I've been told that the keyword filter has not been used since April of this year. That was the last time it's been used. There are no words in the filter. It's not turned on, and that's a key point that the university has made, is that the keyword filter is used only when necessary, and it was been used.
Okay.
I'm sorry.
Before you said that, I was going to ask you if you can go home now because it's all moot, but I guess not, huh?
Well, again, I think the point of the keyword filter is that it is used on an as-needed basis. The university uses it only when it believes that it sees a what it calls a spam campaign.
Is this a new
no.
modification? So the keyword feature always turned on and turned off after a post?
No, the evidence shows that the university's policy is that it uses the keyword filter when it sees that there is going to be a spam campaign, and it defines that itself by a deluge of off-topic comments that are coming in.
How can
to
the
post.
university know before it creates a post whether or not the blocked words on the keyword filter will be off topic?
What happens is that if it sees comments coming in to, for instance, animal rights advocacy, there are no posts on the page related to animal rights advocacy. And it gets back, so what happens is the university would take words that it sees from these comments coming in, it had to put them into the filter, turned on the filter, and then that blocks off-topic comments, hundreds, from coming in and disrupting the posts that are not related to the comments coming in. So that I
And
want to
so
make clear.
I thought my understanding from the record is that the university represented that it could do that, but at the time of the lawsuit, it was not implementing that type of policy as far as the keyword filter.
Well, the keyword filter comes on and comes off depending on spam campaigns, and the evidence showed that yes, there were spam campaigns, and the
And does
university.
the evidence show that the keyword filter was not turned on before the post?
Well, I guess the question is what post you're talking about, Your Honor, because
Let's use the September 2020 Dairy Cow post.
okay.
Was the keyword filter on or off?
When that came on, it may have been on. It may have been on when that post was made. But again, that is something that took place far in the past. As I said, now the policy is that it turns on when a spam campaign is about or is taking place, and it turns off thereafter.
And what was the timing of that policy change?
Well, it's always been in place, Your Honor. Whether there are specific times and how long the keyword filter is on and off, that is not in the record.
Mr. Kilpatrick, your brief says that social media managers may remove comments based on one criteria: whether they are unrelated to the topic or purpose of the page. But they can also remove obscene comments even if they are related, right? Yeah. And also comments about Trump and Biden, presumably even if they are relevant. So, for example, my comment would be hidden if I said, congratulations to Linda Greenfield, a University of Wisconsin alum and current Political Science Board of Visitors member, for being nominated by President Biden to be ambassador to the UN, wouldn't it?
It would depend on the post, Your Honor. And that's my point here is that.
I think that's the example of the post.
I just gave you the example.
I'm sorry. The post was congratulations.
Right.
And then your comment was?
But it mentions President Biden.
Okay. So
But
if
that's
there were
more-
a keyword filter,
Isn't that one? Never mind. Go
well,
ahead.
if there were a keyword filter in place at the time, then yes. But there's no evidence that there's such a keyword filter in place all the time with regard to Biden and Trump. The point here of the keyword filter is that it is not used all the time. It is not on all the time, unlike some other cases that were discussed. This is turned on and off. And again, I say represent to the court that it hasn't been used since April.
Let me drill
at
down
least.
just a little bit on Judge Rovner's point. How does the university decide whether a topic or whether a comment is on topic or off topic? What's the guidance given to the social media manager? Using her post, Judge Rovner's example, what's the guidance?
So there's, yes, the social media statement takes the large view that it maintains the right to remove off-topic comments. Then there's an interim guidance that is directed to the social media managers at UW-Madison, and they are to evaluate the stated purpose for which the page or post exists in the context of comments, the subject, topic, or purpose of the initial post to which the comment is attached. So there is this link between the subject matter of the post and the subject matter of the comment. Ms. Krasno would like to say that there is no link. She wants to be able to comment
No,
her
she
views,
doesn't want viewpoint discrimination.
right? But she wants to comment about her views on animal advocacy, animal rights advocacy. And she wants to do that to a post, for example, that the university makes congratulating the women's volleyball team on its national championship. And in a non-public forum, the the university has considerable selectivity in determining what is germane.
But
And
even in a non-public forum, the university is not permitted to engage in viewpoint discrimination.
That's correct.
So irrespective of the forum, viewpoint discrimination is not permitted. Going back to Judge Rovner's example, the social media manager that has just posted about President Biden nominating a University of Wisconsin alumni, what is the guidance given to the social media manager as to, now that people are going to begin commenting potentially about President Biden, potentially about the nominee, what's the guidance that is given to the social media manager?
Again, one, from the social media statement, it can't be off topic. A little
How is
more
this
guidance.
not different from the Mansky case where the Supreme Court said the word political in polling places, too broad, too much discretion? You got to go bound and put some guardrails around it. That's where I'm just trying to get clarity on that. And
Well-
how are we able to distinguish it?
Well, here again, I believe that the thread, the link between the post and the comment needs to be the subject matter, the topic of the thread of the post to the comment. And again, the social media managers are told to evaluate the stated purpose for which the page or the post exists in the context of the comments, the subject, topic, or purpose of the initial post. And so with that, there is guidance given to the social media managers.
But do they have to be subject matter experts to determine whether or not it's on or off topic?
No, I don't have to be subject matter experts. Obviously, there is some use of common sense here. And also, there is the ability of social media managers, when there are gray areas, to contact Office of Legal Counsel. But there are certainly examples of social media managers that will hide off-topic comments, and that is those are stated in the brief.
Does the record reveal that I'm sorry, Judge Rovner, go ahead.
Finish, please.
Does the record reveal anywhere that the university has targeted off-topic comments unrelated to animal testing?
I'm not sure what you mean by targeted. There's examples of removal from the post, comments that are not
In
related.
the keyword filter?
In the keyword filter, no, again, and that's because that the university sees a spam campaign, and the evidence shows that a vast majority of those spam campaigns are run by animal rights advocates. And so it makes sense then, if the university is to use the keyword filter, it would see the words in the comments that are being used part of the spam campaign to put those in.
I am
They're removed.
skeptical about this claim that the university would turn off the filters if comments about animal testing ever became relevant. For example, let me give you an example, please. If the university posted about a new deal in which Nike would be supplying the basketball team with brand new leather basketball shoes. So let's say Ms. Krasno might want to comment something like, Nike could provide vegan leather shoes that would perform just as well and avoid animal deaths. Do you think this would be on topic? And that's my first question. And my second is, how would the university know when a comment about animal rights might be relevant?
Well, again, Your Honor, there's discretion given to the social media managers. If the social media managers are unsure if it's a gray area, they'll contact legal Office of Legal Affairs, and likely it would be, in the abundance of caution, likely it would remain there. But there are certain
Wait, what would remain there?
it's likely, I can't tell you yes or no whether that comment is on topic or not. What I'm saying is that social media managers would contact legal affairs, and the legal affairs could say, well, leave that comment on in the abundance
Wait a
of
minute,
caution.
you are legal affairs, I take it.
Well, I'm sorry, I meant in-house counsel legal affairs.
I see. Well,
So is that anywhere in the policy that they're to reach out? and not make that decision on their own, that they are to reach out to legal counsel?
Yes, I believe that's in the interim guidance. It certainly was in our brief, Your Honor. And so my point is that this is the district court was correct in finding that this was a non-public forum. The university desires discussion on the topic of its posts. The appellant, on the other hand, views the social media pages differently. She sees them as her own personal soapbox that she can make comments and replies to posts about anything related to the university. For this reason, her comments about her views against animal testing that is taking place at the university is too broad. The university does a lot of things. The university has an observatory. Does that mean that in response to a post, again, by the university congratulating the women's volleyball team, simply because it has a university, Ms. Krasno would be able to comment, or anyone, comment about aliens, UFOs, because the university has an observatory? That's what she says is that animal testing on all of the posts are related to the university because the university performs invasive primate research. And so
Mr. Kilpatrick,
Yes.
if the university put a notice on its social media pages that said, anyone who comments about animal testing before they can, let's see, anyone who comments about animal testing will be banned from this site. Would that be a prior restraint on speech?
That would be a viewpoint discrimination, likely prior restraint, and that's not what has been happening here. Miss,
Well, can you distinguish that comment from a filter that prevents most comments about animal testing before they can be seen? I mean, why isn't it a prior restraint? Just help us with that.
because what that assumes is that Ms. Krasno has the ability to issue a comment about animal rights advocacy to a post that is not germane. Again, there is
Counsel,
no,
I don't understand this whole line of
Yes.
argument. Why don't you just give up? This is obviously subject matter discrimination, and is probably many other kinds of discrimination. But I thought the main argument is the university is entitled to do just that. Right? The university surely thinks it can do that in the alumni magazine, that it can have a no Krasno policy. Right? Why are you trying to defend this case on the weakest conceivable ground?
because there is no intent to discriminate against Ms. Krasno or her colleagues in the
That's
animal
a
rights.
question of fact. What you want to do is win this case on the law. But if you choose not to argue the law, you guarantee yourself a loss.
Well, I believe we've been arguing the law with regard to what type of a forum is this, and it's our contention that the
Does she
district
have
court was
standing
right.
to contest the keyword filters?
Pardon me?
Is there standing to even contest the keyword filters?
There is no standing to contest the keyword filters as they are not being used to block views of animal rights advocacy altogether. Again, what matters is that the comment be related and germane to the post. And the keyword filter is used to counter spam campaigns, in which there's this deluge of comments, usually all the same, and vast majority from animal rights advocates that contain these words. And so the keyword filter is used. But if Ms. Krasno has no right to make off-topic comments in the first instance, then she has no standing because there's not going to be any harm. There's no threat of injury to her because she has no right in the first instance to make comments on off-topic.
I am
Saying
lost.
she has no standing because she loses on the merits? That's not a normal standing argument.
No, Your Honor, is because
What you said is she has no standing because she has no rights. And that's just backward.
well, again, the the decision of the district court was first to determine what is the forum. And we believe that it's right that the forum is non-public. And the non-public forum allows the university to have an off-topic rule. If the comment is
Have
off-topic,
any
merits
rule it
argument.
wants.
well, it enforces the off-topic rule, Your Honor.
Oh my.
Thank you very much, counsel.
Thank you, Your Honor.
The case is taken under advisement. Our next case for argument this morning is the Equal Employment Opportunity Commission against Walmart Stores East. Mr. Setlin.
Thank you, Your Honor. Mishat Saitlin for Walmart. It's a pleasure to be here with you this morning. After Walmart's new scheduling system began scheduling Ms. Spaeth to work from 1 p.m. to 5:30 p.m. instead of noon to 4 p.m. as had been the case before, Ms. Spaeth's attendance issues worsened substantially. This continued even after Walmart gave Ms. Spaeth multiple coaching sessions and also gave her multiple months to correct her attendance issues.
Mr. Chapman, time is kind of, short, so I'm going to start you right off, if you don't mind.
Thank you, Your Honor.
Why weren't Miss Stevenson's 2 interventions on her sister's behalf enough to indicate to Walmart that a schedule accommodation was medically necessary? As I understand it, Miss Stevenson expressly drew a connection between Spaeth's Down syndrome and her inability to work the new schedule. So wasn't that enough to suggest that there was a medical need for an accommodation, just as if an employee said something like, "My doctor tells me I shouldn't lift more than 10 pounds." Well, Walmart could have been within its rights to follow up, ask for confirmation from a doctor. But why was the company not bound by a duty of inquiry at this point?
Your Honor, I have a factual answer and a legal one, and they're 2 separate independent bases. With regard to the factual one, is Ms. Stevenson said that there were 3 problems with this new schedule. 1, Ms. Spaeth was getting too hot. 2, that she wasn't able to eat when she wanted. And 3 was that she was missing her preferred bus home. None of those are medically necessary, or she did not attempt to medically link them to her Down syndrome. Now, when she did reference Down syndrome later, she did say, "Oh, it's because she's getting too hot." But EEOC did not argue to the jury that people with Down syndrome, if they have to work an hour later or 30 minutes more, get too hot. So if they had put on that kind of evidence and they had submitted that to the jury, maybe that question would be apt. But the only link that Ms. Stevenson gave between when she mentioned Down syndrome and the 3 problems that she had highlighted with regard to this new schedule was this too hot thing. And that just wasn't an argument that EEOC made with regard to a medical link to Down syndrome at trial. What they did at trial, Your Honor, is they brought in their expert to argue this groove theory. And this groove theory is this theory that apparently folks with Down syndrome have trouble adjusting to change. Now, this is a theory that even though an expert said that most people in the medical community don't know about, and certainly Walmart's retail associates and their supervisors wouldn't know about. So that's my factual answer, and I think that's enough itself to require judgment in our favor. But now the legal answer is that the term medically necessary, which is in the jury instruction that that EEOC agreed to, is spelled out in this court's case law, and is most particular in this court's Extrad case. And the way that an employee or an agent speaking for them, which we have no problem saying her sister is here, conveys medical necessity with regard to a non-obvious accommodation request is you provide a doctor's note or orally relay what your doctor said. And of course, that makes a whole lot of sense because if it's non-obvious condition,
Is there anything in the statute that requires a note from a physician as opposed to a notice from a relative?
there's nothing in the statute, Your Honor.
Anything in the regulations that requires a note from a physician?
Not that I know of.
All right, well, then why wasn't what Stevenson said sufficient? I understand the point of your brief that even most physicians would not understand this particular limitation of somebody who suffers from Down syndrome. But a jury could think that Walmart understood it, having been alerted by Stevenson. And if there isn't any requirement that there be a doctor's note to go with it, what's missing?
Well, the jury instructions say that the statement had to be that this was medically necessary. EOC, the last time I was here in the Walmart case, there was a lot of.
Is that some kind of magic words argument?
No, that's the jury instruction that they agreed to, and also, in Your Honor, that jury instruction comes from this.
I'm asking whether you're making a magic words argument that Stevenson had to use particular words.
Absolutely not, Your Honor.
Okay. Then what's missing as a matter of law in what Stevenson said?
The matter of law is that she did not link it to any medical issue with Down syndrome. The only medical link, and the jury instructions say medically necessary, and those come from this court's case law.
But isn't that triggered after the interactive process?
Not at all, Your Honor. And I think the key case here is Extrand, and I think that case is exactly on point. And if I may for a second, I think it will.
And in that, I think you're going to pull out the language: an employer is not required to accommodate an employee who refuses to hand over medical documentation.
No, Your Honor, that was not what I was going to do. I was going to talk about what happened in Extrand and this court's holding, and I think it clarifies.
That's the language from Extrand, what I just read to you.
Well, I was going to discuss the holding of Extrand.
And the holding just provided it. The employee never provided the employer with evidence other than conclusory remarks after the interactive process had began.
There wasn't an interactive process, that's true, but what this court held is that the employer there, the school, had no obligation under the ADA until the employee, the school teacher there, provided a medical note. And what happened was the sequence was important. In September, the teacher lets the school district know, I've got seasonal affective disorder, but provides absolutely no note or medical basis or doctor's orally relayed conclusion that
For
because
15 years, Walmart has worked with this individual.
Right.
For 15 years. Okay? So that distinguishes Estrand from this case. For 15 years, they've worked with an individual that they know has Down syndrome. This individual, when her schedule is changed, comes to Walmart and says, I need to go back to my old schedule, in essence. And there's plenty of language within the Seventh Circuit that defines for an employer that the individual might not be able to give or exact, right, to be able to make the connection. But where or when, because the jury found differently as to Walmart's responsibility to begin the interactive process.
our position is under Extrand. We did not have an obligation to begin the interactive process until we provided medical information. Now, it wasn't that we were just told, by her or her sister that I need a new schedule and this is Down syndrome. We were told 3 specific things. This wasn't like, and we were told the same thing by Miss Spaeth and the same thing by her sister. 1 is that she's getting too hot. 2, that she wants to eat earlier. And 3, that she wants to take the earlier bus. Now,
I believe that when people, when they talk about her being too hot, the intimation is upset. But I look, the jury could certainly have seen Walmart's way and concluded that it was an honest mistake, but they didn't. They looked at the evidence and they found that Walmart was at the very least recklessly indifferent to her rights as someone they knew was a disabled employee.
Your Honor,
15 years as, my colleague has noted to you. I don't see how we could say the evidence did not reasonably support that decision, especially when the company never engaged in an evaluation of whether a schedule accommodation would be feasible, despite an understanding by at least some of your managers, this is what she's asking for. So it is a problem here.
Your Honor, I'm certainly not trying to avoid the fact that we are trying to overturn a jury verdict, and we have a high burden in that circumstance. Certainly do not dispute that. It is a high burden on us. We did lose at the trial. But this is what we were told is not in dispute. Said that she was getting too hot, she wasn't able to eat when she wanted, wasn't catching a preferred bus home. This could certainly happen with any number of folks who are not disabled, who really like their old schedule.
But she also told, Ms. Stevenson also said she has Down syndrome.
Right, and then she said, right after that, she said that she couldn't physically handle working. She was getting too hot.
She said she couldn't physically handle working that late. That's the transcript at
Right, Your Honor.
45:15 through 48:12.
Absolutely.
So it's important not to cut off the conversation. She said
Absolutely, Your Honor, and I apologize if that's what I was doing there. But my point, and if EEOC at trial had put on some evidence that said, yes, this you work that late, it's too hot, that's a problem for folks with Down syndrome in general, or Ms. Smith in particular, we would have.
Aren't you reversing the burdens here? I mean, Dr. Smith talked about her distress and depression, Ms. Stevenson's testimony. I mean, what more is the EEOC required to offer?
I mean, as Judge Pryor, pointed out, the link that her sister made between the mention of Down syndrome and the challenge she was having was this too hot thing. If EEOC had put on any evidence at trial or had presented to the jury this theory that she needed an accommodation because she was getting too hot, then you would have a different case. That is not at all the theory they put on. They put on a completely different theory. They put on this groove theory, and a jury's verdict can't be upheld on a basis that wasn't argued to it. They put on this groove theory, and the groove theory was conceded by their very expert. The only medical expert at trial is not known even in the medical community well. What they say in their response brief, well, look, it's known to a specialized cohort of doctors that work with folks with Down syndrome. We have no truck with that. And if we had been given a note or even an oral relaying of this groove theory by Ms. Stevenson in these conversations, would have taken a different approach. But that's not what happened. Only thing she said was, it's too hot, wants to eat earlier, wants to take the bus home, and that is not at all the groove theory.
And she also said, I can't, this schedule, I want my schedule changed.
Yes, Your Honor, and certainly that is consistent with any able-bodied employee wanting to go back to what they were doing. And that's why the medical necessity jury instruction and this court's case law is so important. Is we can't assume. Lots of employees were very unhappy about this new automated schedule change because they've gotten used to the way of doing business. We can't assume that someone that's disabled, all the problems that they might have in the workplace are related to that. Now, if I could reserve the balance of my time, I would greatly appreciate it.
Yes, but I do have one quick question. Does the record tell us what steps, if any, Walmart has taken to correct the apparent misunderstanding on the part of some of its managers that long-term schedule modifications are not permissible as a means of accommodating an employer's disability?
Certainly, the written policies allow for long-term accommodations, including schedule changes.
Thank you.
So why was Stevenson told that was absolutely impossible?
Right.
Well, so what was said was impossible.
We are essentially getting into the cross-appeal issue in which the EEOC wants an injunction, particularly an injunction against implementing the policy the way it was apparently implemented in this case.
Oh, well, Your Honor, with respect, it wasn't implemented in this case in that way because she never even got through the threshold of getting any accommodation because we didn't see her as requesting any sort of accommodation. That's what happened here. Now, with regard to the somewhat conflicting testimony of some of our employees, that is a separate issue. But with regard to how she was treated, she never got to that point in the process because that's not how we were treating her request.
Okay, thank you, Mr. Setlin. Ms. Sharon.
Good morning, Your Honors. Chelsea Sharon for the EEOC. I'd like to begin where you started with Mr. Setlin with respect to the express accommodation request that Stevenson made. I just want to point out that Mr. Setlin tries to frame these as though they were discrete occurrences and issues that had nothing to do with Ms. Spaeth's difficulty adjusting to the routine, what Ms. Stevenson invoked. Yet these are all manifestations of her difficulty adjusting to routine. Ms. Stevenson said because she has Down syndrome, she's having specific difficulties. There were physical difficulties adjusting to the routine, that was getting too hot and physically being unable to handle working that late. There were also everyday and ordinary difficulties adjusting, like missing her bus due to confusion about the schedule and not being able to get home in time for her dinner that she usually had with her stepsister. So to frame these as though they're completely separate from the limitations that were argued at trial is incorrect. I'd also point out that Ms. Stevenson did explain that getting too hot, becoming confused, needing to have a specific schedule were related to the Down syndrome, and that evidence was presented to the jury. I'd also just briefly like to address the point about this court's decision in Ekstrand. The reason that case is distinguishable is it dealt with the employer's duty to actually provide a requested accommodation after the interactive process had already begun. The employer in that case had been engaged in the interactive process for months. It had already provided a number of accommodations to the employee, and the issue, this court reasonably said, was that how was the employer to know that this specific accommodation, as opposed to the others that the employer had already provided, was medically necessary and was the key to her improvement if they did not have a doctor's note. But here, Walmart simply disregarded the accommodation request entirely, never engaged in the interactive process, and so never got to the step where it might have sought corroboration to determine whether this particular accommodation, as opposed to another, was necessary to address Ms. Spaeth's Down syndrome. Now, I'd like to turn.
And
I'm
I
sorry.
take it from your brief that, and from what I guess you just said, that if Walmart had asked Ms. Spaeth's family to provide a letter from a physician confirming that due to her Down syndrome she needed a schedule accommodation, the family would have been obligated to supply it. And your point, I take it, is that Walmart had a duty to inquire and to ask for such medical corroboration as part of the interactive process. But that never took place. So that's what we're left with.
Precisely, Your Honor. And if there is a business necessity to request that corroboration, if it's not obvious that the medical necessity of the accommodation, then of course Walmart would have been able to ask for that as part of the interactive process, but that's not what happened here. If there aren't any further questions about this issue, I'd like to turn to the cross appeal, but I'm happy to.
It wasn't addressed a moment ago, but about the punitive damages
Yes.
award and abuse of discretion on the compensatory damages. I don't know if that's something that you wanted to address before you talk through your cross appeal.
Sure, Your Honor. With respect to punitive damages, the entirety of Walmart's argument rests on the notion that this was simply an honest mistake and that it didn't know that Ms. Spaeth needed an accommodation. And the jury soundly rejected that theory of the case and found that Walmart knew that she needed an accommodation and nonetheless refused that accommodation, terminated her, and then refused to reinstate her. So based on that set of facts, Walmart does not even really attempt to dispute that this would be a case of reckless disregard rather than mere negligence. Turning to compensatory damages, there's no basis to disturb the district court's determination that this was a proper compensatory damages award, not to remit that award. The jury heard poignant testimony from Ms. Spaeth's relatives, from Ms. Spaeth herself, from her physician, about the depression and distress that were caused by her termination from Walmart. And all Walmart says is this was extremely brief and limited testimony, but they don't explain why that detailed testimony can be characterized in that manner. Turning to the cross appeal, Your Honors, the district court abused its discretion here because it ignored relevant evidence of the likelihood of recurrence, and it also committed legal error. But I'd like to begin with the relevant evidence of likelihood of recurrence. Here, there was ample testimony from senior Walmart.
I'm much less concerned about evidence
Yes, Your Honor.
than about what the EEOC was requesting.
Yes.
The district judge understood the agency to be asking for a general obey the law instruction,
Yes, Your Honor.
injunction. Was that a correct understanding of what the agency was then asking for?
No, Your Honor. There was one
Did the
provision.
agency give a list of potential directives that would be beyond just obey the law?
Yes, Your Honor. We had 12 specific enumerated requests. We're pursuing 8 of those on appeal. All of them, with the exception of request number 3, were discrete measures such as training, correction of policies, adding incentives for Walmart managers to comply with certain internal policies that didn't simply require Walmart to obey the law. It didn't say Walmart must comply with the ADA. It said Walmart should take these discrete measures. And the idea is to ensure compliance with the ADA, but they're more granular, discrete measures. The district court did not explain why the court lumped together all of these measures as, quote, for the most part, directives that Walmart comply with the law. But the district court did subject
But
all of
did he
those
pull
measures.
apart a little bit, though, looking at those 8 measures that we're talking through on appeal? The judge did provide some guidance in regards to the training that you're requesting. It's already something that Walmart does. The training for the particular managers at this store, they have annual training on ADA policies, procedures. The facts of this case, that it happened to this particular employee, doesn't demonstrate that it was widespread. And so beyond the finding that the majority of these requests were kind of obey the law, doesn't he give us, though, some additional reasons for why he denied the injunction of request?
I have 2 responses to that, Your Honor. The first is that the notion that these were obey the law measures infected the entirety of the reasoning because it led to reversing the burden for EEOC to show that the conduct could not possibly be resumed, whereas that burden falls on Walmart, of course, to demonstrate that the illegal conduct could not possibly persist.
But are we taking that quote out of context?
I don't think so, Your Honor, and it's true that the district court correctly stated the legal test, but then proceeded to apply it in a way where it criticized EEOC's purported failure to meet its burden, while not even identifying any burden that Walmart itself had discharged. With respect to the policies and trainings, I just want to point out that there are only 2 policies that the district court cited that have anything to do with the ADA's reasonable accommodation mandate. These are the precise policies that Mr. Spudi was shown on the stand. He read them on the stand to himself and testified that they only contemplate short-term schedule accommodations and not long-term schedule accommodations. So clearly there's a lack of understanding. Mr. Spudi is a regional director. He oversees more than 100 stores, more than 30,000 employees. Clearly whatever training and policies are in place are not sufficient to allow Walmart managers to understand that those accommodations are contemplated by the ADA. Your Honor, I would just point out also that below, Walmart took the litigation position that it was not required to provide permanent schedule accommodations as a matter of course, as a categorical matter. It asserted in its closing that the idea that we're going to provide someone with a permanent schedule accommodation is not something that we do. And now Walmart is backing off from that position, but that's what it argued to the jury. And in fact, the district court criticized Walmart for taking this position, saying that the idea that there's never a need for a schedule accommodation flies in the face of the relevant regulations, which is correct. I'd also just point out that this court's decision in Brusso reversed a district court's denial of injunctive relief, where the issue was that the district court had relied on the mere existence of formal policies without considering whether there was evidence of noncompliance in practice. And in that case, the only evidence of noncompliance in practice was simply that the managers had not complied in the past with the policy. But here we have even more than that. We have senior Walmart managers on the stand asserting that they understand the policies to actually prohibit the ability to provide a permanent or a long-term schedule accommodation. So there's additional evidence that these policies are not being implemented in the manner that Walmart is claiming they're intended to be implemented. I also just want to point, I'm sorry, Your Honor. Were you going to say something, Judge? Sorry. Just turning, Your Honors, to the geographic scope of the injunction, the district court did mention that it believed this to be a unique incident involving only one store, but the evidence, of course, shows that there was the involvement of national level managers, or a national level manager, Denise Morgan, who was located at the corporate headquarters, and of a regional director, Mr. Spoody. And that fact alone allows for the imposition of injunctive relief that extends beyond the store level. This court in AutoZone pointed to the fact that managers beyond the store were involved as a basis to affirm a region-wide injunction, and said that the district court had appropriately crafted the geographic scope of the injunction because of the involvement of managers beyond the store level. I'd also just briefly like to discuss the concerns about paternalism that Walmart has raised here with respect to the point about awareness. And I think that it is odd to argue that it somehow promotes the dignity of disabled individuals to refuse to provide them with the opportunity to engage in the interactive process when they've expressly requested an accommodation. And this court rejected a similar argument in Sears, where it pointed out that the employer had said that it would be inappropriate to make assumptions about the employee in that case who walked with a limp. It would be inappropriate to assume that she had a disability just because she walked with a limp. And this court said, no, once an employee has raised a specific disability and raised the need for an accommodation, then the employer is in fact it's not only appropriate, but the employer is in fact required to engage in the interactive process with that employee because she has specifically asked for assistance. And that's what happened here. The Knapp case that Walmart repeatedly cites about purported paternalistic concerns simply deals with paternalism involved in assuming that a given activity is too risky for a disabled individual. It certainly doesn't stand for the proposition that it's paternalistic to engage in the interactive process when an employee requests it.
This must be about the 47th time you've used the phrase interactive process.
Yes, Your Honor.
Where do I find that in the statute?
Your Honor, it's not in statute.
It's not there.
It's not there. You're
It's
correct.
bureaucratic jargon for what is in the statute. And I, at least, would be happier if we talked about this statute in the terms used by the statute.
I
Less
agree, Your Honor.
bureaucraties is always better.
I understand. It has become a sort of judicial shorthand, but I do understand that that term doesn't appear in the statute directly. You're correct about that. If Your Honors have no further questions, I would ask that you affirm the jury's verdict in the award of punitive and compensatory damages, but reverse the denial of injunctive relief and remand for the entry of an appropriate injunction. Thank you very much.
Thank you. Mr. Setlin, anything further? Since you tried to take rebuttal time with about 2 minutes remaining, I will round you up to 2 minutes.
Thank you, Your Honor. I appreciate it. Just briefly on the cross appeal, whereas I said to Judge Rovner that in overturning the jury verdict, we have a heavy burden in overturning the district court's well-considered equitable decision not to award injunctive relief based upon the extremely broad requests that they made, they have a very heavy burden. And while the term obey the law and the injunction, obey the law injunction is kind of a judicial shorthand. I mean, if you take a look at what they actually asked the district court to do, they weren't trying to tailor the request to the store or to long-term scheduling changes. Each one of these requests basically involves broad, either nationwide or region-wide receivership, essentially, of Walmart, based on what I think it was fairly characterized as a close case where we had a fair disagreement about whether what she was asking for was a reasonable accommodation, something medically necessary, or was something where we made a
I could
mistake.
understand you would have a better argument if the district judge had said something like that. But the judge didn't. What the judge said is, they're just asking for an obey the law injunction, and that's not appropriate.
Well,
Well, they have asked for more than that. One of their requests, just to be concrete, is Walmart can no longer assert that it never makes long-term schedule adjustments as an accommodation, right? That's one injunction that the judge could enter. And I didn't see the judge discussing that possibility at all.
Your Honor, I might be wrong, but I do not believe that was one of their requests. What their requests were much broader on a regional or a nationwide level, is that we can't deny any long-term accommodations, and if not tailored to schedule. Now, look, they decided to go for the home run. They decided to ask not for store-wide like they tried to do.
I'm sorry, that's not accurate. It says the number 6, require Walmart to provide training to its managers and supervisors regarding the obligation to grant schedule accommodations under the ADA in the absence of undue hardship, and to remind them that a request for a scheduled accommodation from a person with a disability cannot be denied at the store level.
Yes, so that's the only one of those that refers to schedule, and it doesn't talk about the long-term aspect. And so, they can try to amend.
Look, I understand that you might disagree with some of the language, but my concern, and perhaps that of my colleagues, is that the district judge never got into the nitty-gritty of this. District judge at a very high level says, well, they're just seeking obey the law relief, denied. And the kind of discussion we are having here doesn't seem to have happened in the district court.
Well, Your Honor, as a threshold matter, Judge Griesbach did say that we satisfied our burden, that this conduct would not likely to recur again, could not recur again. So his discussion of obey the law injunctions was only a backup. Second conclusion, and that first conclusion is entitled to very substantial deference, and that they have a very heavy burden to overturn.
I think it would be somewhat of a problem to write off all 7 of the injunctions requested as obey the law injunctions, particularly where, for instance, number 4, number 6, which relate to work schedule accommodations and relate specifically to the type of misconduct that the jury found Walmart committed in this case. And they are aimed at preventing a recurrence. And then number 4, well, that would be number 6, I guess. And number 4, which simply requires that Walmart notify its employees of the verdict in this case and remind them of their right to contact the EEOC without being fearful of any retaliation. I mean, it seems that that's a relatively straightforward demand that doesn't require ongoing supervision by the court. So those 2 I do worry about.
So certainly number 4 is the least onerous one of the requests that they make, and the only one tied really to the facts that were found by the jury. The rest of them, while they can either be characterized as true obey the law or implicate the exact same concerns as obey the law, which is you word it so broadly so the EEOC doesn't have to bring a lawsuit and can just bring a contempt motion. It really triggers the same concerns as obey the law injunctions.
Mm-hmm. All right, thank you very much, counsel. The case is taken under advisement, and the court will take a 10-minute recess before calling the 3rd case. hear argument now in the case of United States against Avila. Mr. Slade.
Good morning, Your Honor, and may it please the court. Mike Slade for Refugio Avila. I want to focus on two issues: the scope of the traffic stop and the timing of the Speedy Trial Act findings. On those issues, the district court extended 3 recent decisions from this court: Cole and Smith on the Fourth Amendment issue, and Shanu on the Speedy Trial Act. We believe they were stretched too far that this court should reverse. I want to start with the scope of the stop. Cole and Rodriguez make clear that traffic stops must remain limited in scope, and police may not detour from the mission of the stop to investigate other criminal activity. Here,
Does it matter? Forgive me, but does it matter? Do you think that Officer Fosco testified that he extended the stop in order to keep looking for evidence of criminal activity, if in fact a reasonable officer could have extended the stop for safety purposes?
I don't believe that that matters. I believe the question is, why did they extend the stop, and did that give grounds to reasonable suspicion? And I believe that the existence or not existence of reasonable suspicion is a question that this court reviews de novo. And the officers here admitted that before and after each pat-down, they intentionally detoured from the mission and extended the stop intentionally to look for evidence of other criminal activity. And the admissions are very clear in the cross-examination.
Because the Fourth Amendment inquiry is objective, what weight should we give to that statement?
Well, it is objective in what a reasonable officer would have thought in light of those particular admissions. I don't believe that that you can discount these particular officers' admission about what they had in their own mind and the reasons that they made the decision. I think the question is whether a person that believed these things, as these officers did, had reasonable suspicion to go further. I think that's the right question.
I would really think that you might want to go on to the Speedy Trial Act problem that you have argued, because the government argues that you agreed to exclusions of time. Can you tell me exactly what you think was agreed upon in terms of excludable time?
So in March of 2021, the parties submitted a joint status report to the court in which they agreed to the exclusion of time for purposes of the court deciding the pretrial motion. That's what was in the status report. That's not dispositive or even particularly relevant to our view of the Speedy Trial Act issue, because the Supreme Court held in Zedner and reaffirmed in Bloat that Speedy Trial Act violations cannot be waived. Now, I think that question is certainly relevant to whether the dismissal should be with or without prejudice. That absolutely is a relevant question. But whether or not there was a violation of the Speedy Trial Act is a question of what the statute actually says, substantively. If there was a violation of the Speedy Trial Act, whether or not we agreed to it, 3162 of the Criminal Code is very clear that the court shall dismiss. And the question is only whether the dismissal should be with or without prejudice. I'd be happy to...
And that's very important to you. And there isn't much discussion of prejudice to your client from the Speedy Trial violation. If we were to reverse on that claim, would the case have to be remanded for a determination of prejudice? And can you give us a preview of what your prejudice argument would be?
So I agree with Your Honor that the case would have to be remanded for a discussion by the district court about whether the dismissal would be with or without prejudice. The district court did hold at the end of the Speedy Trial Act that had it been violated, he would have dismissed the case without prejudice. It was an alternative finding, and we wouldn't challenge that. Below, we would agree that the case should be dismissed without prejudice. But at this point, Mr. Avila has served his entire sentence that was ordered by the court. He actually he's back in prison because he violated the terms of his supervised release, but that would have to change if there was a remand and the case was dismissed for violation of the Speedy Trial Act. We think the Speedy Trial Act issue is just the plain language of the statute applying this court's ruling recently in the Shanu case. Shanu stated, and the government doesn't dispute, that a retroactive ends of justice continuance must be supported by findings that were made, even if only in the judge's mind, before the continuance was granted. And that's the Shanu case reading from Zedner. And a court is not supposed to make after-the-fact rationalizations to justify a Speedy Trial Act extension. But that's exactly what happened here. The last exclusion of time was on March 8th of 2021. And if you look at the facts that he relied on to justify the Speedy Trial Act extension, those didn't exist on March 8th of 2021. Almost none of them. The only thing that existed on March 8th of 2021, when he last excluded time, was briefs, initial briefs that were very short, noticing up the suppression hearing for a hearing, and the status conference. That was it. That does not justify, and could not have justified at the time, a 15-month continuance. I also think it's pretty telling that most of the cases that the judge relied on in denying our motion to suppress were decided way after the suppression hearing took place. The Cole decision came out 6 months after the suppression hearing. The Smith case, I know Your Honor was on the panel for that case, Judge Rovner. The decision in that case came out more than almost a year after the suppression hearing took place. That is not what Congress had in mind when it wrote the Speedy Trial Act.
Had in mind? How do you know what any member of Congress was thinking at the time?
Fair question, Your Honor.
Well, what we know is what they enacted.
I completely agree. What they enacted is a statute that says if you do not put somebody to trial within 70 days of the indictment, and if you don't make these findings, then a case shall be dismissed. That's 3162 of the Criminal Code. And when this court interpreted that statute in the Shanu case, it also made clear that retroactive ends of justice findings were acceptable only where there was no indication that the court was continuing the case on account of a crowded calendar, and no indication that this was an unreasonable continuance given the facts of the case. And the district court's decision below turned both of these prongs on its head. When we first raised this issue at a status conference, the first thing the district court judge said was that it operated on geologic time, given the amount of time, things on its plate at any one time. And then when we asked, how long is it going to take you to rule on the suppression motion, the judge said he wouldn't be able to tell us because of the 1,001 things on his plate at any one time. Now, if these admissions, these statements, which were on the record at a status conference, are not what this court was referring to in Shanu as an indication that the court's delay was on account of a crowded calendar, which is not permitted under Shanu and the case that it cites, then I'm not sure what would be sufficient to satisfy that. And as to unreasonableness, remember that the Speedy Trial Act allows 70 days total. This motion to suppress was pending 15 months, and it took nearly 70 days to get a ruling on the Speedy Trial Act motion. Your Honor, we believe the Speedy Trial Act violation was very clear, and at a minimum, the court should reverse and order a dismissal without prejudice for that reason alone. And I would like to reserve the rest of my time for rebuttal unless Your Honors have any other questions.
Certainly, counsel.
Thank you, Your Honor.
Mr. Fullerton.
Good morning. May it please the court. The district court did not abuse its discretion in denying the motion to dismiss on speedy trial grounds. The district court found, well, first of all, the district court excluded time through the resolution of the motion to suppress by the agreement of the parties. That covered the period from, I believe, March of 2021 until the motion gets resolved in the summer of 2022. Now, the better practice, of course, would have been to make findings about interest of justice along the way as the court is going through the case. But at the time it excluded, in March of 2021, when it excluded time based on the pretrial motion, as the court later explained, it thought it had meant to exclude time based on the interest of justice. This is exactly...
Well, look, could we... Tell me, What about this case is particularly complicated?
I'm sorry, Your Honor, I didn't hear that.
I am just wondering on the Speedy Trial Act problem. What about this case is particularly complicated? How is this case different from the thousands of other motions to suppress in which police pull over a suspected bad actor on the premise of a seatbelt violation, faulty taillight, and then search for evidence of a suspected crime? I'm guessing that none of us would be able to count the number of cases we've seen with these exact facts. I'm wondering, where is the complexity to begin with? I mean, the judge goes on for 90 pages. That transcript is 90 pages of how complex this case is. Help me.
Yeah, Your Honor, I think you raise a good point, which is, I agree with you that the legal issues are not that complicated. The district court clearly wrestled with the factual issues. And Mr. Avila had challenged these officers and their account of what happened during this traffic stop at every step of the way, from their observation of the Dodge Journey to the observation of the traffic violation, their observation of a seatbelt violation. Every single step of the way, Mr. Avila had challenged the officers' credibility and their account of what had happened. So this was recorded on body camera. There was a 2-day hearing, a 300-page transcript, and the district court, I mean, to its credit, took these issues very seriously. And I mean, it's fair to say that the district court kind of wrestled with these questions, ultimately concluding that the officer's account was credible, and that there was reasonable suspicion for each step that the officers took during the traffic stop. Now, part of the time that the district court took in resolving the motion to suppress was based on its understanding that Cole, this court's decision in Cole, the panel opinion in Cole, which was heavily relied upon by Mr. Avila in his motion, had been granted en banc review in June of 2021 and took some 5 or 6 months until December of 2021 to get resolved. Mr. Avila considered that case to be very important. He relied on it heavily in his motion. And the district court, I think, reasonably decided to wait for the en banc resolution.
Can he rely on the United States versus Cole case that goes en banc June 9th of 2021 if he made the decision in March of 2021?
Oh, so, right, Cole, the March of 2021 exclusion of time based on the agreement of the parties was found later to be justified by the district court based on the interest of justice. That was permissible in Chano. The court's explanation of its findings for the interest of justice related back to the case as a whole. Things that had taken place.
Mr. Fullerton, look, if the district court judge wanted to wait until the resolution of the Cole case, why didn't the district judge simply issue an order when he learned about the en banc, excluding the time while he waited? Wouldn't that have been the way to do it?
Clearly, the better practice would have been to make exclusions along the way. Clearly,
No, wait, the better practice.
Clearly, that would have been the better practice. This court has made it very clear that's the better practice. It didn't happen here, but I don't think dismissal is required. The court did make the findings that justified the exclusion at the time it denied the motion to dismiss on speedy trial grounds. And those findings,
I guess I'm trying to drill home the point that when United States versus Cole is brought to the attention of the district judge, the continuance is already in place.
correct.
And so if we're trying to connect this end of justice finding was made at the time of the continuance, how are we able to rely on United States versus Cole? And the fact that that case did raise some concerns regarding the traffic stop.
Yeah, I think the answer has got to be that the later justification for the interest of justice exclusion can account for what took place during the pendency of the motion.
Okay.
And I think that's permissible under Chanu and Ramirez, because what Chanu and Ramirez appear to say is that a post hoc rationalization for an interest of justice exclusion is not permissible if it relies on something that is not apparent in the record. The reliance on Cole, the length of the hearing, the bitterness with which this motion to suppress was fought, all of those things were evident from the record. And there's nothing like happened in Ramirez, where the only justification for delay was the congestion of the court's calendar. So I think that answers the question.
Do you think that some of what the judge actually said in those 90 pages about how he has to move at glacial speed and how much there was on his plate, and I mean, does that veer a little bit, do you think, into my calendar business here?
As I said, Your Honor, I think that the district court, clearly wrestled with these factual findings. It perhaps thought that they were more evenly balanced than he found them, but I think that's to the district court's credit that it was taking these allegations very seriously and really went through this with a fine-tooth comb. Now, this is not a simple motion to suppress where the parties just rely on a police report or a single body cam. This involved testimony, 2 body cams, and a 2-day hearing. So I think it was perhaps, I would concede this is not the best practice. It was a long time, but I don't think it was an abuse of discretion to deny the motion to dismiss on speedy trial grounds. Regarding the motion to suppress itself,
I guess we should talk a little bit then, based on that point, the May 16th statement made at the status hearing. And so it's my understanding the government defense counsel gives a synopsis of the speedy trial. I'm going to call it the problem. And the response from the government was that the overview that the defense counsel, has provided is accurate. And so I'm just trying to make sure that I understand the position the government is taking now versus the position the government took at that status hearing.
I don't believe the government conceded that there was a violation of the Speedy Trial Act. The government's attorney was agreeing that this is what had taken place. This was the extent of the exclusions that were on the record. This is the sequence of events. But it certainly wasn't a concession that a Speedy Trial Act violation had occurred and that dismissal was required. Regarding the motion to suppress, the district court made factual findings that were supported by the record, which justified a reasonable suspicion on the part of these officers, or reasonable officers in their place, that justified the traffic stop, getting Mr. Avila out of the car, patting him down, doing a protective sweep of the area near where he was sitting, the subsequent pat down, and the third pat down, which revealed the firearm concealed on his waist. That was supported by entirely new facts that gave the officers reasonable suspicion. Namely, Mr. Avila's behavior once he was out of the car, kind of facing the car, the corner of the car, appearing to be hugging the car, and then the pat down only occurred when the officers directed Mr. Avila to approach them, and they saw a bulge on an area of his body that they had not previously frisked. So this entire interaction between Mr. Avila and the police officers took some 6 minutes. That's not an unreasonable prolongation of a stop. And their search for a weapon was not an impermissible purpose, did not go beyond the mission of the stop.
I think we have your position, counsel.
Thank you, Your Honor. So we ask that you affirm. Appreciate it.
Anything further, Mr. Slade?
Thank you, Your Honors. As your colloquy with my colleagues established, I think, this case creates a big timing problem. If what Mr. Fullerton says is right, then district judges don't have to make any findings under the Speedy Trial Act at all. And then 3 years later, when the defendant makes a motion, the district court can recite what happened over the last 3 years and use that to justify the extension of time. That's not how the Speedy Trial Act works. There's no cases justifying that interpretation of the statute. It's inconsistent with Zedner and Shanu, and I think would fundamentally upend district court practice under the Speedy Trial Act. This court found in the Shanu case that retroactive interest of justice findings are not best practices, and they're permitted only when the findings were in the mind of the judge when he had last excluded time, when nothing in the record indicates that the case had been continued due to a crowded calendar, and when the delay is not unreasonable. This case does not satisfy any of those prerequisites for a retroactive interest of justice exclusion. The record has a lot of evidence that it was being continued on account of the court's crowded calendar. The facts he relied on didn't exist at the time he last excluded time, and Mr. Avila spent 15 months in prison, nearly a full guideline sentence, waiting for a ruling on his motion to suppress. I do not believe that that's consistent with the language or spirit of the Speedy Trial Act, and we would ask that you reverse. Thank you, Your Honor.
Thank you, Mr. Slade. And Mr. Slade, we appreciate your willingness and that of your law firm to accept the appointment in this case and the assistance you've been to the court as well as your client.
Thank you very much, Your Honor.
The case is taken under advisement. We'll hear argument now in the case of United States against Williams.
Good morning, Your Honors. May it please the court. Your Honor, I would like to focus on the arguments, particularly regarding substantive and procedural errors by the district court during the sentencing hearing for Mr. Williams. Now, there are several of the arguments that are also mentioned in my brief, but I would like to at least start in focusing on those main errors. The basis of start with the procedural errors. The basis of the procedural errors is that the district court did not explain its reasoning in dealing with the main argument of the unwarranted sentencing disparities among defendants. And what I mean by that is, during the sentencing hearing, there were several individuals that testified on behalf of the government. There was a Ricky Rapp who received a sentence of 15 years, a Ronnie Bodke who admitted to selling drugs at the Flop House where an individual actually died from an overdose, although that person claimed that they had nothing to do with it. But that individual, Mr. Bodke, was never charged with a federal case and only received a sentence of possession, simple possession, at the state level, where he received his sentence was served at 50%. You had a Dustin Test who received 190 months, a William Zamaro who quite honestly is very disturbing in the disparity here, in that this individual admitted to giving another victim of overdose.
Mr. Beals, it sounds like you're making an argument to the sentencing judge, which we're not, right? Have we ever held that a sentencing judge erred by imposing a sentence within the guidelines, that it erred on the ground of excessive disparity?
No, Your Honor, I don't have a...
Ever. The answer is no. And one reason is that the Supreme Court held in the Gall case that a sentence within the guidelines necessarily reflects proper attention to the need to avoid unwarranted disparities. So it sounds like you're asking us not only to do something for the first time, but to disagree with the Supreme Court in the process. And that's usually not something we are anxious to do.
Well, Your Honor, I am asking the court to do something for the first time, not necessarily to disagree with the Supreme Court in Gall. In this situation, under 18 U.S.C. 3553A6, the court does have a directive to avoid unwarranted sentencing disparities.
And the Supreme Court said in Gall that a district judge who imposes a sentence within the guideline range, and I quote, necessarily gave significant weight and consideration to the need to avoid unwarranted disparities. You're asking us to hold otherwise.
Well, Your Honor, now under Gall, that would be an argument under a substantive error. Now, in this situation, we're talking about, I'm initially talking about a procedural error. Now, procedurally, the court still has a responsibility to explain any issues regarding any arguments made by the defense under 3553. And even though the court did give a within guideline sentence at the time of the sentencing, the court still has a responsibility to explain its sentence, particularly any arguments that are of merit. And I believe in this situation, the arguments by the defense made during sentencing were very much so of merit. It's difficult to look at the record where you see the wide range of sentences that these individuals received based on similar conduct. I would argue same conduct. Many of the individuals who testified on behalf of the government admitted to having a significant number of meth customers, and all of their sentences were well below my client's sentence, who received a sentence of 30 years. And some individuals...
We don't tell you how to allocate your time, but half of your time is gone, and you may want to address other arguments.
I appreciate that from the court. Just also, and just wrapping up my argument regarding procedural due process, Your Honor, in light of the fact that so much of the argument that was made at the sentencing hearing was made regarding the unwarranted disparities, I believe that the court still had a duty, even under Gall, even though the court did give a sentence in the guideline range, it had a duty to address the reasons why my client received such a large sentence in comparison to the other defendants. Now, it's also wanted to also address, there were some other issues that the court mentioned. One was that the court mentioned that in making one of his explanations that my client did not have a drug habit. I just want to just touch on that briefly. My client's drug habits were mentioned in the PSR. Also, my client's sister testified during the sentencing hearing that he did have a drug habit. So there was evidence presented during the sentencing hearing that would have addressed that that the court also ignored. Now,
are you arguing that he was addicted to meth?
What I'm arguing, Your Honor, is that my client had a drug habit. I'm not necessarily arguing that my client was addicted to meth, as opposed to the fact that he did have a drug habit. And one of the reasons, and this goes again, and not to try to belabor and continue to use additional time of mine on the procedural argument, but that does go back to the procedural issue. The court, in delivering its sentence, seemed to allude to the fact that these other individuals were meth addicts, or i.e. drug addicts, and that was to some explanation as to the difference in sentencing, when in fact my client is a drug addict. To say that that an individual who has a drug addict other than being a meth addict, and because they're not a meth addict but they are a drug addict, somehow they are more culpable in the distribution of meth than other individuals. That also is just, it's not a good explanation, and that explanation was without merit. So
the judge did give some additional reasons beyond that. I know we're hinging on you sold for your financial gain while the other defendants were drug users, which make you more culpable. The judge also went a little further and said, but this is the reason why your sentence is higher. You controlled and managed the network. You have the most methamphetamine that was available to sell. You directed where the purchases would occur. You cut some dealers out. He also argued or stated and gave the statement, you have provided me with anything today to seriously consider going below the guidelines. He noted on the record that Thomas Wright, another defendant, had received 300 months in imprisonment, and the judge went further and said, the reason why yours is justifiable as to why to go higher, there's not any question that you were the supplier for these other, I'm going to call them co-conspirators.
Well, Your Honor, one, it's difficult to call them co-conspirators, especially since there was evidence presented at the sentencing that in many respects they were competitors. Two, many of these individuals also admitted to having networks of clients at the same number of clients as my client had. Three, Mr. Wright, that individual that the court specifically mentioned, who had a 300-month sentence, was a career offender, and his background is significantly worse than my client's background. So, that's kind of a.
Did Mr. Wright threaten 3 of the 11 witnesses?
Well, there again, regarding threats to the later witnesses, we have no idea whether Mr. Wright threatened any of his customers who owed money. Now, regarding the likelihood of the actual threats, there was some conflicting evidence regarding that. I mean, you had some statements that my client supposedly threatened the client was looking for him, and yet he was with another client. Well, I see my client and my time is getting ready to run out. Please, the court.
You can finish answering Judge Rovner's question.
There was evidence to show that when my client was allegedly looking for one of his clients who supposedly owed him money that he was making threats to, he was with a Mary Lazari. And when he was with Mary Lazari, he was actually pulled over by the police. He was actually searched by the police, and I believe he was taken into custody by the police briefly. And with him being searched, it shows that he was not charged with possession of a weapon or even possession of drugs. So that contradicts some of the government's witnesses' statements that supposedly he's making these threats and he's this violent individual. Now, the other alleged threats.
Judge Rovner, do you want to follow up?
No,
Okay.
thank you.
Thank you very much, counsel.
Thank you.
Mr. Bertrand.
Good morning, Your Honors. May it please the court, counsel. My name is Nathan Bertrand. I'm appearing here today on behalf of the United States. And we're asking in this case that the district court sentence be affirmed as it was procedurally correct and was substantively reasonable. Just to jump in on a point that was made by Judge Pryor in talking about the sentencing disparity. The judge in this case, at the district court level, acknowledged the defendant's criminal history. It referenced his tragic childhood, acknowledged the testimony of his family, and then went on to explain the breadth of his criminal conduct. As was pointed out, citing Mr. Wright's 300-month sentence as the highest so far, and then providing a detailed explanation as to why the defendant in this case was going to receive more punishment. Yes, the government's witnesses were drug dealers. The defense counsel here said there were several witnesses. To be clear, 10 drug dealers were cooperating and testified as to how many customers they had, and that the defendant, in this case, was their either sole or primary supplier. The judge explained the defendant in this case was on a higher spot within the drug trafficking pyramid. He was the one supplying all of these drug dealers with the methamphetamine that they were then selling in Peoria and Tazewell County. To address the point of the drug habit, the government pointed out in its argument, I believe it's page 382 and 83 of the transcript, that there were some inconsistencies with what the defendant was telling probation at various times in his interviews, and was essentially saying that the defendant was trying to gain favor from the court by portraying himself as a drug addict, when in fact he may not have been. And the court even specifically said on page 419 that it did not believe that the defendant was selling simply to support his habit, like some of the government's witnesses were. Just to address a few of the other points that the defendant brought up, in terms of the issue with the purity of the methamphetamine in this case. The defendant waived that claim. At no point did he object in the pre-sentencing report or at sentencing as to the purity. He in fact stipulated to the base level offense here, and counsel explained at sentencing that this was a strategic decision. The threshold here for that base level offense was 4.5 kilograms of methamphetamine actual. The government was showing evidence at sentencing of 48 kilograms that the accused could be held accountable for. In fact, defense counsel explained that to maintain the objection would have been frivolous.
What evidence, if, assuming that it was not waived, what evidence do we have to support the drug purity used in the PSR calculation?
Yes, so in the PSR, there were 5 separate paragraphs in which drugs had been tested by the DEA laboratory here at the North Central, I believe, Chicago laboratory, citing that it was either 100% purity, 98% purity, and then at sentencing, a chemical analysis report was submitted to correct the PSR, showing that on another occasion, drugs that came from the accused tested at 96% purity. So there were multiple instances where drugs attributable to the defendant were tested and were above the threshold to be methamphetamine actual. And in regards to the sentencing enhancements for the threats and the firearms, again, numerous witnesses testified that they had either seen the defendant with a firearm, a few said that they had sold him firearms or traded him firearms in return for methamphetamine or to settle their debts, and numerous individuals testified that they had either been personally threatened or they had seen the defendant threaten other individuals, and text messages were actually introduced at sentencing showing some of those threats. Unless there are any additional questions for me, the United States would rely on our brief, and we respectfully request that this court affirm the district court sentence.
Mm-hmm.
Thank you.
Thank you very much. And Mr. Beals, we appreciate your willingness to accept the appointment in this case.
Thank you.
The case is taken under advisement. We'll hear argument now in the case of Pierce against the Whiteside School District. Mr. Shue.
Good morning. My name is Mark Shuver, and I do represent the Pierce family. If it please the court, counsel, when the district court dismissed my client's discrimination claims under the ADA, the Rehab Act, and state law, it did so not having the benefit of the Supreme Court's most recent decision in Luna Perez versus Sturgis Public Schools. In Perez, the court made clear that the exhaustion requirement under the IDEA only comes into play if 2 elements are met. Number 1, under the Fright analysis, that the crux or gravamen of the non-IDEA federal claims deals with a free, appropriate public education of faith. And number 2, more importantly, and which is centered on the express language of the IDEA, specifically section 1415L, the remedy sought must be one available under the IDEA. Both elements must be met. But here the district court looked only at that first element, the gravamen of the complaint, without taking into consideration the remedy that was being sought. In this
Mr. Speaker, forgive me, in Perez, as far as I can tell, the plaintiff had requested only relief that was not available under the IDEA, compensatory damages. In this case, the complaint in count 7 seeks relief for denial of a free, appropriate public education, and the request for relief sought also includes, quote, all other relief that the court deems just and proper. By including this, wasn't the plaintiff here asking for compensatory relief and possible equitable relief? You see, your brief states that you asked only for compensatory damages, along with prejudgment interest, fees, and costs. But that isn't quite correct, because you also asked, as I just noted, for any other relief the court deems just and proper. And couldn't that be equitable relief available under the Individuals with Disabilities Education Act, or IDEA?
No, Judge, because the court would not have had the jurisdiction or authority to do that, because if exhaustion was in fact required, it could not have ruled on that. And in Perez, the court specifically addressed if that were true, the remedy is not to dismiss the entire lawsuit. In Perez, the court specifically referenced when there is a mix of relief that the court would just either bar that relief or defer it until exhaustion had been accomplished.
So looking at count 7, are you seeking equitable relief?
No, we are not. Under no circumstance. We've made that clear. We made that clear before the district court. We've made that clear before this court. The only thing we are seeking is compensatory relief. Of course, I think probably every pleading that everybody drafts has that tag-along language about all other relief that the court deems just and proper. It's just boilerplate, and why we all do it, I'm not even certain.
I'm sure today you're not certain, but
What do you,
you know,
say
there
about
are-
the federal rules of procedure, which say that the prevailing party gets the relief to which he's entitled, no matter what he asks for?
That would be true, Judge, and we would not be entitled if, in fact, there would be an exhaustion requirement. So the court could not grant such relief.
But
If that
the
were the
problem
case.
is that the school was not accurately carrying out an educational plan, right? The relief to which the prevailing party is entitled is to carry out such a plan.
The relief we are seeking, this is no different, Judge, than if I walked into a movie theater and somebody said, I don't care that you're deaf, get out of here, I'm not letting you see a movie. Or I'm not letting you use the devices that you probably have here in this courtroom for people who are hearing impaired. If you were to tell me, and I'm hearing impaired, that I could not stand before you and present an argument, I believe I would have an ADA claim. I believe I would have a Rehab Act claim. And this is no different. The context of in this case was it was in a school. But that doesn't mean, and in fact, both in Fry and in Perez, the Supreme Court made clear, there's going to be overlap. There's no question. So that overlap does not defeat any of these claims. The bottom line is, Judge, Your Honors, that the only damages we are seeking here are compensatory. Furthermore, this was not a jurisdictional issue. This was something that was strictly something that should have been raised as an affirmative defense. That's what happened in Fry. That's why the court had to remand it back down to the district court, because there was not an accurate record. There was no discovery. And that's exactly what happened here. So I would like to reserve the rest of my time, but we are asking that this be reversed and remanded. Thank you.
Certainly, counsel. Ms. Lampernakos.
Good morning, Your Honors. May it please the court, counsel. I think the plaintiff relies on Perez, but I think Perez, we have to understand that there's a clear distinction between what was happening in Perez and what we have in this complaint that's been filed in this case. In Perez, the IDEA issues, the FAPE issues were all resolved. The only thing moving forward in that case was the discrimination claim. Here, that's not the case. We have a complaint.
Why do you think it makes a difference?
I think it makes a difference, Your Honor, because in this case, we have a complaint that contains not only a count that specifically asks for relief under FAPE, but we have, out of 126 paragraphs, 71 of those paragraphs specifically either relate to and identify the IEP, or they reference the failure to implement the IEP. So I think that's a very important distinction. And for counsel, for now we're saying we're only seeking compensatory damages. For purposes of this appeal, we're limited to what his complaint is asking for. And part of his complaint is asking for remedies that are available under IDEA.
But how is this different in the Perez case, where the Supreme Court explains that the IDEA claims that could have been brought here, the equitable relief that you're requesting, that might be barred or deferred. However, it doesn't prevent the ADA claim from moving forward. And so I guess where I'm trying to get clarity on is, in Perez, there was a settlement agreement on the IDA claims. Right. And where in the Perez decision did the court kind of use that as the linchpin for why the case could move forward?
Well, I think, Your Honor, the fact is that Perez didn't deal with that specific issue because it wasn't a part of that case. There wasn't an IDEA aspect to that case because it was already resolved. I reviewed the Perez complaint. There isn't a single allegation in that complaint that relates to an IEP or the failure to implement an IEP, where in this case, the complaint is full of those references. So, again, we're bound by what this complaint is alleging. And the allegations, the gravamen of these allegations, which is an analysis that Frye took on, and what the district court relied on in this case, was it is all relating to the failure to implement the IEP. And in terms of the remedies that the plaintiff is seeking, we're not limited to only accepting the remedies that the plaintiff puts on the paper. Just because he's saying he's only looking for compensatory damages, you have to look at what the complaint says.
But the Supreme Court was clear that Frye didn't deal with this issue.
Correct.
Frye said, the Supreme Court in Perez says, Frye doesn't deal with the issue that's presented before us. The issue before us now is whether or not a past denial, right, of claims that can be brought under the IDEA may nonetheless proceed. Can they proceed without exhaustion? If the relief that you're requesting cannot be provided under the IDEA, and compensatory damages, if you agree, counsel, cannot be brought forth under the IDEA.
Correct. That is a true statement, Your Honor. But I think, again, we have to look at what this complaint is saying. In the Perez decision, the court wasn't really dealing with that detail because that complaint didn't allege clearly and specifically violations of the IEP. They were dealing with an ADA claim.
And I guess where I'm losing, I guess, your explanation of the distinction of Perez, there's a particular example, a hypothetical that the Supreme Court gives in that case. If you give me just a little grace, I'm going to read it just so that I can make sure that I understand the distinction that you're making. It says, under our view, for example, a plaintiff who files an ADA action seeking both damages and the sort of equitable relief IDEA provides may find his request for equitable relief barred or deferred if it has yet to exhaust Section 1415 F and G.
Correct, and I don't disagree with that. However, here we're dealing with an IDEA issue that's still live. It hasn't been resolved. And I think that's the crucial distinction. It hasn't been resolved. And I think the district court went to great lengths to look at the allegations in this complaint and parse out what exactly is this complaint looking for. We're not only bound by the relief that the plaintiff sets out, we have to look at exactly what their allegations are and what their allegations are looking for, or what relief those allegations are looking for. Now, if this was a purely ADA claim and wasn't replete with mentions of the IEP and the failure to implement the IEP, we might have a different case. But the fact is that at this level, we are bound by what the allegations of the complaint are. And the allegations of the complaint, as I said, 71 of the allegations of a 126 paragraph complaint all deal with a failure to implement the IEP. And it contains an actual count for a failure to implement the IEP. And that count, at a minimum, that count would have to be abandoned if the ADA claims were going to go forward, because they're actually seeking that remedy. And I think another important distinction, not a distinction, another point that I'd like to make is, the district court, when it did dismiss the case, it did it without prejudice. Plaintiffs were allowed to go and replead. They chose not to. If there was some, ambiguity about what they were seeking in their complaint, the district court gave them the opportunity to replead, and they didn't do that. So I'm sorry.
Yeah. Well, do you know if that throwaway request that plaintiffs always include was included in the Perez complaint?
I have the Perez complaint. If you could indulge me for a moment, I think I can answer that.
I hate to take up your time,
Yeah.
but I am wondering.
Sure. They were looking for equitable and injunctive relief, compensatory damages, attorney's fees, and it does say, and any other relief deemed necessary. But again, I think, as we've kind of established already, Your Honor, that is a phrase that we all use, I think. I think we have to really look at the allegations in this complaint, as the district court judge did, and really pin down what we are dealing with. And if you look at the allegations in this complaint, there's no question that it is centered on the failure to implement the IEP. The failure to implement the IEP, the failure to train the teachers on the IEP, it's 71 paragraphs of that. And I don't think we can get away from that. And I think, I'm sorry, and I think another point that's worth making is if this case is remanded and we are forced to proceed on the complaint as it is currently styled, we're going to be in a situation where the district court is going to have to make rulings on the sufficiency of these educational services that are spelled out in the IEP. And the whole purpose of IDEA was to have specialized hearing judges who are trained in these educational services to hear and address those questions. If there are no further questions, I thank you, Your Honors, for your time.
Thank you, counsel. Anything further, Mr. Schuler?
Yes. With respect to the alleged distinction in Perez about that case being resolved, that is not what the court hung its hat on. And in fact, what opposing counsel is essentially saying is we would have had to have exhausted our remedy And that's what Perez is saying we don't have to do. And in fact, what Perez is saying is we could have gone straight to the courthouse. We didn't in this case, but we could have gone straight to the courthouse without having filed any administrative proceeding at all, because we are seeking solely compensatory damages. That's it, nothing else. Judge Pryor, you correctly cited the language from Perez about mixed relief. We don't have mixed relief here, but to the extent that there is any mix, these 71 paragraphs, whatever they are, that can be dealt with in a less egregious way than dismissing the entire case. As Perez said, you either bar those portions that are mixed, or you defer them until there is exhaustion. This could have easily been remedied by the court simply stating that they were allowing leave to amend. But this was a drastic end to my client's case. We are not limited in our remedies. Both Perez and Fry clearly stated that the plaintiff is the master of her claim. She identifies the remedy and is subject to exhaustion based on that choice. Again, we would ask that this court reverse the dismissal and remand this case for further proceedings. Thank you.
Mm-hmm. Thank you, counsel. The case is taken under advisement. Salem against the Attorney Registration and Disciplinary Commission is our final case of the morning.
Good morning, Your Honors. May it please the court.
We will call you when you are ready,
when
we are ready. Mr. Salem.
Thank you, Your Honor. And may it please the court. My name is Maurice Salem. I'm the appellant in this case. Your Honors, we've read the briefs in this case, and we have an understanding of what this case entails. But today, Your Honors, if you go on the ARDC website, you'll see them telling the entire world that Attorney Salem's law license was suspended because he was dishonest to the public. Now, I believe the two questions that the public listening on YouTube would want answered is how or who made that determination and how was it made? Now, in this case, there is only one fact-finding hearing or trial that took place. That was in October of 2017. You had a hearing board where you had witnesses.
Mr. Salem.
Yes, Your Honor.
What has any of this to do with the Constitution? The Supreme Court has held that defamation does not violate the 14th Amendment, period.
This is not a defamation claim, Your Honor. This is
a claim of defamation. You're seeking to avoid basing it in state tort law. It's a defamation claim, and the Supreme Court has held that the Constitution just doesn't deal with defamation. It's a state law issue.
I agree with that, Your Honor, but I believe...
I'm glad you agree with the Supreme Court.
I do, Your Honor. If you give me an opportunity, I can proceed and explain to the court. There was only one fact-finding hearing that took place. Well, first of all, my claim is a discrimination of a class of one where there's ill will and malice. And in the Willow case, which this court started, that is a claim, and that's what's pending that was what was pending before the district court. So the issue is whether or not the administrator had ill will and malice. That's what you need to determine. Now,
are you even aware of Paul against Davis, the Supreme Court case to which I'm referring?
Vaguely, Your Honor. What is your point?
Ill will was alleged in Paul against Davis.
Yes.
It was alleged that there was a gratuitous, completely outrageous falsehood that was actually put up on posters rather than just on an internet site. And the Supreme Court said that kind of behavior does not violate the Constitution. And here we have a similar claim by somebody who is simply ignoring the decision of the Supreme Court. That gives me some pause.
Well, Your Honor, the point is, the substantive due process claim cannot be ignored because the hearing board issued censure, and no other case where an attorney received censure was like mine. In all other cases that where censure was recommended, there was an attorney who did something intentional for profit. In my case, the hearing board found that there was no intentional violation and no profit. Now, Your Honors, when they filed a motion for leave to appeal in the Illinois Supreme Court, all the Illinois Supreme Court did, they didn't grant the motion or anything, they just simply increased the punishment to the second most severe punishment next to disbarment, where even
Why didn't you file an answer to the ARDC's petition?
And I will. I'm not. This is the first time I went in front of the Illinois Supreme Court. I'm familiar with the U.S. Supreme Court, Your Honors. Now, in the reason I didn't file an answer is because no answer was required, Your Honors. And the petition that the administrator's counsel filed in the Illinois Supreme Court was so ridiculous and frivolous, it was sanctionable. And I was shocked. Excuse me, Your Honor.
Would have had the opportunity to have your arguments heard before the Illinois Supreme Court if you had filed an answer.
Right, Your Honor, but no answer was required, and I thought the Illinois Supreme Court was going to act like the U.S. Supreme Court. Unfortunately, it did not. But the important thing, Your Honor, is that by issuing the second most severe punishment next to disbarment, that raises the substantive due process claim in addition to the discrimination of a class of one, ill will and malice. And the Roker-Feldman doctrine, unlike what the lower court said, can't apply because the claim arose at the time the punishment was issued, because that's when substantive due process claim rises, Your Honors. Now, in the district court, Judge Tarp, in his decision, he implied that the administrator made a mistake in putting on the website that Salem was dishonest to the public. He implied it's a mistake and said,
Is there some reason why you have not sought relief under state law?
Well, Your Honors, I didn't believe there was a need to go into state law. If you're talking about defamation, Your Honor, I believe this fits perfectly with the Willow case, where the government official used their power to attack their enemies. Your Honors, I've been fighting
That sounds
corrupt
like
government.
the kind of thing that the circuit court would deal with as a matter of state law.
It would,
Is
Your
there
Honor.
some reason why you have not sought state law remedies?
Your Honor, I would have to get back to you on that, to give
No,
you a
you're
full
never going to
answer.
get back to us on that. The question is here and now. Is there some reason?
No, I can't think of one right now, Your Honor, but I don't believe there's a reason for me not to be able to come into the
Other
federal
than Paul
court.
against Davis, that is a holding of the Supreme Court of the United States. That is a sufficient reason, one might think.
Well, but Your Honor, this case is different. The facts, I believe, are different, and I believe the substantive due process claim and the discrimination claim are very powerful here. Your Honor, let me just also explain. I filed a writ of
Mr. Salem, I
mandamus.
have a somewhat related question to ask.
Yes, Your
The
Honor.
most recent time you were here was in a state of Watar. And the bottom line of that case was that we affirmed a $20,000 fine against you for
Yes.
engaging in frivolous litigation over the course of years. Has that fine been paid?
No, Your Honor, but that's another
Is there
issue.
any reason why we should allow you to continue litigating when you do not pay the sanctions imposed against you?
Yes, Your Honor, because the public is listening on YouTube, and because I filed a writ of mandamus, this court has to consider the appearance of conflict of interest and injustice, Your Honor. And because I filed a writ of mandamus,
The
I preserved that
problem,
issue
Mr.
here.
Salem,
Excuse me?
is that all of your claims and suits are frivolous. You have been sanctioned over and over and over. You don't pay the sanctions and continue filing frivolous suits. Is there some reason why we should not enter a MAC order?
Your Honor, that's false. That's a false blatant. The only one sanction that was succeeded, and that was the one with Judge Cox. But let me just say,
Then there's the Pellin case, where you were ordered to pay your opponent's attorney's fees. And I gather from having done a little research that you haven't done that either.
Your Honor, that case is pending, and there's nothing that.
Have you paid?
No, I have not, Your Honor,
Right.
but I believe that.
So, is there any reason why we should not enter a MAC order?
I'm sorry, I didn't hear you, Your Honor.
Is there any reason why we should not enter a MAC order?
I'm not familiar with the MAC order, Your Honor.
No. Well,
But in any event, I believe that this case is, from the public's point of view, Your Honor, I've been fighting corrupt government officials all my life since 1980. I've been succeeding most of the time. I had a chief of police and a
In
lieutenant.
this case, though, you've raised the class of one discrimination in violation of the equal protection. So I'm just trying to get wrap my mind around how is this case that you've alleged distinguishable from defamation?
Defamation is a claim, and maybe I should have brought that in, but I wasn't thinking defamation. I was thinking more, this is a government agency using its power to attack an enemy, someone who fights corruption in the government all his life, that's been doing that. And so I believe that the Willow case and the class of one discrimination was more appropriate than defamation. But you know what, in retrospect, maybe I should have done that. But at this point, the class of one discrimination claim exists. The substantive due process claim, which arose when the Illinois Supreme Court imposed their punishment. And so, and again, Your Honors, I believe it's critical for this court to uphold because in the public, you have law professors and you have experienced appellate attorneys listening in on this. And so I strongly urge this court that to consider requesting supplemental memorandums on pivotal issues that it believes it can use to affirm the lower court. And I see my time is up. Thank you, Your Honors.
thank you, Mr. Salem. Mr. Split.
Good morning. May it please the court. Well, I think what I'll do is entertain questions. If you'd like me to go through the district court's reasoning, I certainly could. We believe that the district court got it right in finding that the claim, the equal protection claim with regard to the attorney disciplinary summary was a reasonable interpretation of the Illinois Supreme Court's order. If one understands.
I just don't see how that's a federal issue. It might be a state law issue.
Well, with the plaintiff being, I guess, master of his complaint, then the district court tailored its analysis under an equal protection analysis, and you know, I guess perhaps better a defamation claim, but I maybe didn't want to go off.
I don't think the holding of Paul against Davis can be avoided by artful pleading. It's just, right? I was surprised that Mr. Salem didn't mention it. I'm even more surprised that the defendant didn't mention it. You have an absolutely dispositive decision of the Supreme Court, and it doesn't get mentioned.
I've got no real explanation for that. I raised a number of issues before the district court for dismissal, and I admit that that was not one of them. So based on what the district, I'm sorry, Judge Rovner.
Can you explain a bit about the facts that led the ARDC hearing board to determine that Mr. Salem did not intentionally hold himself out as an attorney in Illinois, but rather did so inadvertently?
Right, yes, sure, I can do that. There were a number of counts in the complaint against Mr. Salem, 7, I believe, and one of them was that based on what he had been doing with his letterhead and business cards and corporate filings between 2010 and 2015 was him holding himself out to the public as an Illinois lawyer when he did not have an Illinois license. One of the counts was that he specifically did so in a case to a judge in connection with the pleadings in the case and also a letter that he sent to the judge. So there were separate counts, and we lost the count at the hearing board that his general activities between 2010 and 2015 was an example of him dishonestly holding himself out to the public as an Illinois lawyer. We won the count. We had the testimony from that judge who came in and said, yes, I was presiding over the case for 18 months. I thought he was an Illinois lawyer. It wasn't until I saw this that I learned that he was not an Illinois lawyer. So we won that count. And that's how the facts shook down at the hearing. And so if one understands then what happened after the hearing, you can get to the realization that the Jerry Larkin's interpretation of the Illinois Supreme Court suspension order was a reasonable interpretation, because we lost a lot of counts at the hearing board, but we took one count, the holding himself out count. We took that to the review board, and our claim was, we think this finding or failure to make the finding by the hearing board was against the manifest weight of the evidence, based on the evidence that's already been admitted in the record. And we lost the review board, but we had another shot, and we took it with the Illinois Supreme Court. And we raised a single two-part issue, and that was, we believe it was against the manifest weight of the evidence for the hearing board to find, based on the evidence in the record, that respondent or plaintiff did not hold himself out dishonestly as an Illinois lawyer. And if the court agrees with that, we believe that the appropriate sanction is suspension for 90 days until further order of the court. As this court pointed out, plaintiff did not file an answer in which he could have argued that we were full of it and that we didn't have a good argument, but he didn't file an answer. So what happened after that was, after the time for an answer had passed, the Illinois Supreme Court issued an order that allowed our petition for leave to file exceptions and imposed the very sanction that we had asked for. So at that point, we put together summaries of the disciplinary cases to post on the website, as is our obligation to the public by virtue of the Illinois Supreme Court's guidance. And we looked at the case, we looked how it happened. There was a single issue before the Illinois Supreme Court asking for a sanction. The Illinois Supreme Court granted that and imposed the sanction. So our interpretation was, well, they agreed with our issue, which was that the hearing board's finding or failure to find this holding out count was against the manifest weight of the evidence. And that's really the crux of what respondent is complaining about. Now, respondent does not understand or refuses to accede that the Illinois Supreme Court can make that kind of review. It can look at the evidence in the record and make a determination as to whether this was sufficient for something or not. Criminal defendants, as this court knows, do it all the time. They get convicted, they bring an appeal, they're allowed to claim to this court that the evidence was insufficient to convict. There was no requirement that the Illinois Supreme Court hold any sort of evidentiary hearing. This is not any sort of thing that happens because of chicanery by the Illinois Supreme Court. It's a basic manifest weight of the evidence issue. And we won on that issue in the Illinois Supreme Court. So based on what had happened in the case, we interpreted the order, put it in the attorney disciplinary summary, and posted it on our website like we do for all orders of discipline. And that's kind of how we got here. Plaintiff is incensed that we said that he acted dishonestly, but if you understand what happened going up to the Illinois Supreme Court, that's the finding. And certainly, I think the idea that this was a reasonable interpretation is borne out by the fact that the Northern District's Executive Committee interpreted the order exactly the same way. When Mr. Salem went to the Executive Committee and tried to get his reciprocal discipline there lowered, he claimed to the Executive Committee, look, the only thing I did was make an inadvertent mistake on an appearance form. And the Executive Committee said, no, no, no. If you look at what happened, just like I described to you, the Supreme Court adopted the PLE, found that you were, and imposed the sanction that was requested, so we reject your interpretation that the only thing you did was inadvertent. So that's kind of where we're at. And the district court, we believe, correctly determined that plaintiff failed to show that our interpretation of the Supreme Court's order was completely irrational. And because there was a reasonable basis for it, there's no equal protection claim. If there's no further questions, thank you for your time.
Thank you very much. The case is taken under, your time has expired. Your time has expired. The case is taken under advisement. Court will be in recess.